We have here 4 individuals who all come from different backgrounds and have different experiences with the Public Information Act. And I first want to basically have them introduce themselves and describe their background with the TPIA. And let's start with Representative Giovanni Capriglione.
Hi, everybody. My name is Giovanni Capriglione. I'm the state representative for Northeast Tarrant County. I represent South Lake, Colleyville, Grapevine, Keller, North Fort Worth area. This past session, I was on the General Investigation and Ethics Committee, and I was also the vice chairman of the Government Transparency and Operations Committee as well. I've been working on open government legislation since I first started. It was the first bill I ever filed. We've had some successes, and we'll talk about some of those, hopefully, and some of the not so much successful. Thank you.
Hi, my name is Frank Battle. I work in the Speaker's office. I was the general counsel until 2016, and I retired and came back for the last session in a reduced capacity and did not work on the Public Information Act legislation. But I had done that in the past. I worked on it during the time I was general counsel in the Speaker's office. And before that, I worked in the Lieutenant Governor's office under David Dewhurst as the general counsel, and I was also responsible for following Public Information Act legislation. And I need to add a little disclaimer. I'm not speaking for Speaker Strauss today. I'm here on my own. I'm here to share my own wisdom or lack thereof.
Afternoon. My name is David Foy. I'm here to hopefully parlay some of the private sector impact on public records. I work for a company called Relex Group. We own LexisNexis, so those attorneys in here have probably used us before in one manner or another. And I'm the central director for government affairs for them. Previously to that, I worked approximately 15 years in various positions in Florida government and moved to Texas, got here as fast as I could. So I have a little bit of experience with the TPIA and a lot of experience in other states with their public record laws.
Brian Collister, I'm an FOIFT board member, also investigative reporter at the NBC affiliate here in Austin, and I use the TPIA just about every day and use it extensively for investigative work, and also get involved with legislative issues because of the impact on our work and the public's right to know.
So as you all know, the Texas Public Information Act was adopted in 1973 in the wake of the Sharpstown stock fraud scandal. And the purpose of the act is to ensure access to information held by the government. In preparing for this panel, I think all of the panelists had different overarching concerns about what the TPA has morphed into since 1973. And I'm going to let each of them tell you what their concerns are currently with the status of the TPIA. Brian, you want to start?
What I have seen through my daily use of trying to obtain public information is that it's getting harder and harder. And I think those of you that are journalists or activists or otherwise may have experienced the same. There are a growing number of exceptions, and exceptions that just don't make sense. And the one that comes to top of mind is a bill that I believe was up this session that had to do with the dead suspects, which is, as a younger reporter in San Antonio, there was a shootout at a Denny's downtown. An officer was killed after a suspect drew a gun out of another officer's holster. We asked for the surveillance video because we were told that incident was being used to teach other officers how not to make that mistake of leaving your weapon exposed. And we were denied by the Attorney General's office because the case had not resulted in a prosecution. The guy was dead. That just doesn't make any sense. And more we're seeing cases like that where information that should be public is being blocked by an exception that was certainly not intended to apply.
Right, and let me mix this up a little bit. Frank, you were probably around when the law enforcement exception was adopted. What was it intended to apply to?
I don't know. I don't recall.
Okay. Well, tell us what your concerns are about the TPIA.
Sure. I've worked on this as a policy issue in both the House and the Senate. And the way I see it, there are 3 interest groups that are I guess, fighting over this, and they all have separate concerns. So first with what I would call the requesters, which is the people in this room, the Freedom of Information advocates. There have been some significant changes to the Public Information Act as a result of court decisions. I don't fault the Attorney General's office. I think they do a great job with what they're, with what they're given. But I think that these court decisions are basically reducing the amount of information that's available to the public. And so for the requesters, it's strictly defense. It's just trying to hang on to what they have. There's a second group, and that would be what I would call the privacy advocates. And it's with technology, this is becoming a bigger and bigger issue. I always, every time red light cameras comes up, this is like a significant part of that debate is people don't want the government to have their picture, and they certainly don't want it released. And so they're basically interested in privacy interests, but one of the difficulties with this interest is that it's not represented by one group. It's individuals, it's the businesses, Greater Houston Partnership. I mean, their basic argument is privacy. And so it's pretty hard to get a handle on this group. The third group is the opposite. It's actually pretty easy to talk to them, and that would be the governmental bodies. You've got the cities and counties and school districts and state agencies, and their number one concern is is basically administering it with limited resources. And so for example, we created a stakeholder group a couple of years ago, and at one of the meetings, Jim Allison, who represents the counties, he said, look, we will do whatever the legislature tells us to do. We're concerned about how we're going to pay for it. And I'm paraphrasing what he said. So that's their number one. Now, sometimes they do try to change the exceptions. They advocate for changes in the exceptions. Like one that I remember was to make teacher appraisals confidential and stuff like that. But their number one issue is money. It's the underfunded mandate aspect of this. So those are all the things that are going on. And I've observed that pretty much everybody's unhappy with this. It's kind of a mess. The requesters are frustrated. The governmental bodies, if you look at the increase in the workload, they're frustrated. Imagine the Open Records Division at the AG's office is frustrated. I don't know about the privacy advocates because, again, it's such a diverse interest.
Thank you. I think you summed that up very nicely, actually. David, what do you see as the overarching concerns confronting the TPIA?
Sure. So coming from a national perspective, Texas has a good law, maybe not the best law. We represent, or we have clients, 97% of the Fortune 500 companies buys one of our solutions. Those are primarily backed by public records. And that happens because in a society, even though we're the United States that we talked about earlier, there are a lot of barriers. There's barriers to information for companies as well as government. We also have state, local, and federal government customers that are trying to get information from us to help them, whether it's through beneficiaries. The Texas Comptroller's Office uses us for their solutions here to help on unclaimed property, give people their property back. The Attorney General's office uses us for some of their child support enforcement, and they're looking for a national private vendor to help them get information about people. We're a very mobile society. Thousands of people move into Texas a day. Thousands of people move out of Texas a day. And so one of the issues that we worked diligently last year with Laura and the FOIFT team and others was the date of birth issue. Based on the Paxton v. Dallas court ruling. We think that's a very important piece of data for both citizens and private sector companies to have information so we can ensure that the right person gets their underwriting and risk done correctly, that the criminal record that's associated with David Foy isn't this David Foy. I promise I don't have a criminal record. That information is just so important, and with common names in our society today, Smiths, Martinez, et cetera, even a close friend of mine here that lives in Austin, they had the wrong Cooper, And that's something that can follow you. So we as a company, we try to help both the private sector and the government sector, what we call cleanse their records, and make sure that the right person is associated with the right public record that's out there, whether it's in the state of Texas, the state of Louisiana, et cetera. So we're looking forward to the next session, working with FOIFT and others to try to enhance transparency in the system. Again, we think Texas has a good law, but we know it can be a lot better.
Great, thank you. And Representative Capriglione, what are your thoughts on this subject?
Well, when you go and you look at the Public Information Act and you read some of the intent language at the very beginning of the act, it's pretty clear that when it was written and when it was passed, the goal was to interpret any kind of disagreements on what the act says on behalf of the taxpayer, to be as progressive, if you will, in terms of its interpretation, so that the taxpayer is first. Now, obviously, over time, we've added some exceptions, and some of them make sense, right? I'm a big advocate that public information should be public, but real private information should remain that way. What's happened, unfortunately, and again, this is my perspective, is that there are some of those interest groups that Frank had mentioned that are basically doing a better job protecting their interests than others. And by doing that, what that's meant is that the public's perceived first place position in this act is being delegated further and further backwards. And I'll just give you kind of something that should worry us is, okay, so we have Hurricane Harvey. We all want to help as fast as possible and as quick as possible, and at some point Congress will decide that we should, and they're going to provide tens of billions of dollars, and I agree that they should, but put that money into restoration, renovation, reconstruction, all of that kind of stuff down in the Houston area and in the Gulf Coast area. What happens when those people that are receiving these vast sums of money all of a sudden stop responding to these public information acts? How do we know that, okay, fine, it's an emergency, so we get it, the money has to go there, but what if later I want to find out where the money went? Where did it really go? And we've seen in these kind of big, expensive emergency situations, sometimes years later, that the money didn't go where it was supposed to. So that's just one example of many that I'm worried of in this interim where the Public Information Act is going to be siding on the wrong side.
Couldn't agree with you more. We've heard mention of some of the court cases from the last interim that have caused some closure of access to information, and we've also heard many of our panelists, as well as Representative Clardy in the panel earlier today, talk about if you want to know the truth, you need to be able to follow the money. Well, during the last interim, there were 3 significant cases: the Boeing, the Greater Houston Partnership, and the Paxton versus City of Dallas cases, all of which cut off significant amounts of access to the taxpayer. The first one in Boeing, the court sided with Boeing that the information the Port Authority of San Antonio had about its contract should not be releasable. And they basically construed the wording of the test under 552.104 different than the language in the actual exemption, making it a much more lax standard and making it much easier for the private entity to simply say, I'm going to have a competitive disadvantage if this is disclosed, and then that's enough. In the Greater Houston Partnership case, this was one that involved the entity that performs economic development duties for Houston and received hundreds of thousands of dollars annually from the city for this purpose. And what this case does is it basically overturns the law that was in effect for the last 25 years, the Neelan test, and now says that the TPIA requires that an entity be supported in whole or in part by the public funds in order to be considered a governmental body. That's what the law was. Now they're saying you have to be sustained by public funds. They created a higher threshold in order to have access to nonprofit information. So now you've got private entities that basically control the ability to get information about government contracts, and you have nonprofit organizations that are basically able to control whether or not you have access to nonprofit information. The third case dealt with date of birth issues and basically extended the common law right of privacy to close off access to dates of birth for all members of the public. There had been a previous ruling, the comptroller case, that said you can't get dates of birth in employment files for public employees. This actually extended that further and said we no longer have access to date of birth information for members of the public. This is a horrific ruling, and it's one that was actually handed down by the city of Austin, or by the Court of Appeals in Austin, that wasn't even taken up by the Texas Supreme Court. The full extent of this ruling has not been felt by everyone yet. And David, you might be able to speak a little bit more to that issue.
Well, I think you're right, Laura. We haven't seen the impact on that yet, but almost everything we do in society, one of the questions is, date of birth. As we've moved to the digital age, we file a lot of applications online to get a credit card, to buy a car. There are ways of conducting economic business now that we didn't have before. And we're in a society now where we fill out something for credit or want to make a purchase, and that is given to us pretty quickly because of the systems we have in place today. Again, the world may not fall off a cliff, but if you're trying to get a home loan and certain information isn't made available to the finance company or the bank on your loan and your application, that which might be done within a day in an office or 2 days in an office. My father's always telling me back in the day it used to take months sometimes to get an underwriting application today, and today we're sitting on the phone or at our computer and it says you've been approved. When dates of birth or addresses or your full name isn't a part of that economic stream, it can make it difficult for the people that we're doing business with trying to get that data and information. I'll give you an example. I moved to Texas in 2010. When I moved here, my entire life was in the state of Florida. I won't give you the number of years because I'll give you my date of birth away. No, just kidding. So I moved here in 2010 and I started filling out applications, and it was for my electric, decided to get an apartment. Again, all my vital records were out of the state of Florida. Anything I had in any courts was out of the state of Florida. So what do all those vendors here in the state of Texas do? They have to hire people to try to make a determination on my identity. And they have an identity management program to say, let's give him that apartment, or let's turn on his electric and water, or let's give him cable. And that's all done in the background, and people don't always see that. And it's very difficult when, again, there's a mobile society and people are moving from city to city or moving from state to state, because states with privacy laws, they don't share that information with other states. They don't even share it sometimes across city boundaries and county boundaries. So the date of birth ruling is very difficult, I think, both from a government perspective. They're going to start seeing problems in their beneficiary programs, SNAP, TANF, Medicaid, all those type of things. And the private sector is already starting to see it, but that's going to trickle down into government programs as well, because believe it or not, government's getting a lot of that data on out-of-state residents from private sector companies.
Brian, you've got something to add?
And for those of us that are journalists, if we want to do something as simple as go to a school district and ask for a list of their bus drivers, and then go down to the courthouse and get a data set of court records, we can't find the bus drivers that have had DWIs. We can't find anyone with a criminal record. Now, the school districts will say, well, we do all that. We take care of it. The last time I did that before DOBs were cut off, we went to the school district and identified employees that they had who had criminal records. One school district had a janitor at an elementary school who was on probation for delivery of cocaine. We found another bus driver who was on deferred adjudication for drunk driving. And they never bothered to tell their bosses. I don't know why. But those are the types of things that we can't do now.
Representative Capriglione, what have you seen the impact of the court rulings for Boeing and GHP be?
What we've seen on both of those cases, but is that a lot more open records requests, when they're submitted to the local government entity or what have you, essentially there's the third-party challenge, which wasn't really part of it before this. And we're seeing hundreds, I don't know what the latest number is, I'm sure we're at over 1,000 now, actual open records requests that are being denied. And it's, again, I will agree also, it's not the Attorney General's fault. He's looking at the precedent that was set from the court ruling and what their order was. So now, just every day, people, press and so on, but they're saying, hey, I'd like to know about this contract. And they're not going to be able to get that information. And what it does, it isn't just that I can't get that contract, it's now that other people that are entering in these contracts know that no one will be able to see their contract. And we worked a lot during regular session to try and find some sort of compromise, a little bit of a delay, maybe allowing some information that really is competitive, could provide a competitive disadvantage, would not be disclosed. But what I felt was that people just prefer the way that it is now. That was the business sector feels that they like it the way it is now because they just don't have to get that information out there. It's really, quite frankly, it's a chilling effect, and I'm not sure it's going to get any better because while I like talking about this, the more we talk about this, I know more people are like, oh wow, I don't actually have to get that information released. But I'm hoping that in the next interim we'll figure that out. And so that's more on the Boeing ruling. On GHP, this question about whether or not something is sustained makes it a government entity, it's a nonprofit. I mean, we had a chamber, and unlike the senator, I'm not going to tell you the specific chamber, right? But we've had folks come in. I mean, on this chamber, they'll have on their board city council members. They'll get significant amounts of dollars, $250,000, million or more dollars from the city. They have the city's name in their title. They're effectively a branch of the city, but because of those rulings, now no longer have to let the public know how those taxpayer dollars are being used. So, I don't know. I haven't seen anything positive come out of these rulings yet.
Frank, do you have anything to add on this?
Yeah, okay, so on Boeing, I think the most significant thing, first, I agree with the increase in the workload. This is definitely going to increase the workload.
Frank, put the
Oh,
mic a little closer.
okay, this is definitely going to increase the workload. You know, the AG's office is going to have more decision requests. Those require a lot of work. There's briefing. I mean, that's done by the employees of the governmental body and work by the AG's office. And I think for the governmental body, they're going to have to start figuring out who do we send third-party proprietary letters to, because this seems to have expanded the universe of people who would qualify for those letters. But I think the most important point on this, the thing that is the scariest about this, is that in a government contract, you have essential elements of the contract, which would be the details about payment and the details about the work to be performed. And as I read the Boeing decision, that information could be withheld. That is serious, because there is no public accountability. You know, there are other implications, but to me, that's the most worrisome one. On let's see, did you mention
GHP?
City of Dallas? Oh,
Yep, all of them.
okay. So in City of Dallas, this is the one. This is the attorney-client privilege, and I noticed something. I'm not seeing anybody else say this. I don't know if this is an original thought or not, but so if a governmental body misses the 10 business day deadline, then there is a presumption that the information is public unless there is a compelling reason. So for years and years, the Attorney General has said that whether it's compelling is determined by what kind of exception it is. If it's a mandatory exception, then that's compelling. So if information is confidential, you know, it doesn't matter whether you miss a 10 business day deadline or not, it still has to be withheld. And there are criminal penalties for the you know, employees of the governmental body if they don't withhold it. But if it is a discretionary exception, it's waived. Okay, so that's the significance of the 10 business day deadline. So what the court said in this case is that attorney-client privilege is inherently compelling. It's not, you know, there is something about it in the balancing between the public's right to know and the need for confidentiality that attorney-client privilege is always going to be treated as confidential. And so I think an implication of this is that we now have a compelling test that may look at things at a balancing rather than just what type of exception it is. So anyway, that's a significant thing that I noticed with that case.
And that's actually a case that was not listed as one of the top 3 problems during the interim. That case was handed down during the session, and we did try to get that addressed this session as well. It's a bit confusing because there's 2 City of Dallas cases, one involving the date of birth and the other involving the attorney-client privilege.
Laura, can I say one thing about Boeing from a business perspective?
Sure.
And I'm not speaking on behalf of the entire Texas business community, but I know Relix and LexisNexis, we have no problems with our contracts with government or our bid RFP type documents being provided to the public as part of us doing work with a government entity. There are protections in Texas law if you have something that's trade secret or proprietary. There's a process through that agency or government entity, as well as the Attorney General's office, to ask for certain things to be redacted. And we, as a company, we make TPIA requests sometimes when we're a losing bidder. And we want to see it's a competitive business. We want to see what our competitors are bidding. We want to see what type of offerings that they're making to government so we can make our products better. And next time we do that bid 3 years later, that we can maybe do a better bid. So from our company's perspective, we support that, and we see that as a good thing. And so hopefully in the future, some other companies will come along and support as well.
Well, that'd be great. And just to follow up on some of the things that the panelists have mentioned, the AG's office is seeing a huge increase in the amount of requests for decisions. Just in the very first year since the ruling in the Boeing case, they saw over 600 additional requests for decisions dealing with that decision. The chilling effect has been enormous. Sandra Sanchez was supposed to be with us here today, and she wasn't able to make it. She was sick, but she works with the McAllen Monitor, and as y'all have heard, the McAllen Monitor had tried to just simply get the amount of money that Enrique Iglesias was paid to perform at a city concert and was not able to get that. Similarly, the city of Denton tried to get information about a $265 million power plant contract. It is the largest expenditure in the city's history and was unable to get that information. Final contracts are being kept secret now. So during the interim, and Frank alluded to this earlier, we tried to do something as interested parties to address these rulings in 2017. And what we did was we reached out to folks on both sides, not only both sides of the aisle politically, but also both sides of the aisle for the issue of transparency in the TPIA. We all recognized that there is a problem and that none of us think it works particularly well. The governmental entities are overwhelmed with requests and feel in many ways that there's a lack of certainty in, for instance, when do they redact dates of birth? When do they not redact dates of birth? There's the Attorney General's office is overwhelmed. Their work has increased exponentially. And the requesters are frustrated. They're frustrated that they're not getting information that they should get and that they're not able to hold their government accountable. So we put together, at Frank's leadership, a task force. Frank, you want to tell folks about that?
Sure. Well, actually I retired before. I didn't see it to its completion because I left in August of 2016. And when I was in it, I thought we were calling it the stakeholder group, but we got promoted to a task force, yay. So the idea was, basically, as I mentioned, everybody's frustrated with the Public Information Act. And we were looking, I think at the time we were working on what was called the custody loophole, which is where you have public officials or employees who have public information on their private devices, and because of the way the law works, it's difficult or impossible to force them. If they do not want to give that information up, it is difficult to get it. And so the legislation that we worked on, or that I worked on for Representative Hunter in the 2015 session was a kind of a compromise language on the custody loophole. And that sort of led to, and I'm going to go back to Laura. This was actually not just my idea. I think Laura and Donis Baggett had also suggested that we get a group together of interested stakeholders to basically talk this through. And so we had one ground rule, which was if you're opposed to it, it's off the table. And what that does is that forces everybody to keep looking for things that everybody can agree to. And then, as I said, I left in August of 2016, and so that was the state of it at that time.
And that's how it continued. We continued to meet on a monthly basis, and we met with the AG's office, with the governmental entity groups that are on the board there. We met with members of the legislature, with requester groups, with private sector groups, et cetera. And we came to what was an agreed upon platform of legislation to present to the legislature. And you'll see on the PowerPoint up there the various issues that we came to an agreement on with these groups. One was addressing the attorney-client privilege issue, which Frank brought up. That was a bill that was carried by Senator Watson. Another was to deal with the Boeing fix, which Senator Watson and Representative Capriglione carried. There was a more discreet version of that carried by Representative Canales and Senator Hinojosa that addressed just contracts dealing with performers at concerts. The custodian loophole fix, the one that Frank just referred to, as far as being able to reach information on electronic devices when a public official is conducting public business on a private device. That was carried by Representative Hunter and Senator Watson. The date of birth fix was also carried by that same team, Representative Hunter and Senator Watson. And the AG's office was very interested in having an expedited response procedure put in place to help them with the tremendous workload that they have. And that was carried by Senator Watson and Representative Lucio III. GHP fix was carried by Watson and Representative Capriglione. And then there were a couple of measures that were primarily brought forward by the AG's office. One of them was an IT security bill carried by Representative Elkins. Another, well, we all agreed on we all agreed on all of these, but the URL fix was something that was just filling in an issue that had been left open from the last session. Vexatious requesters was one of the big issues. One of the reasons that we started the task force, quite frankly, was to address the problem of vexatious requesters. If you came to this conference last year, you heard people talk about the problem with people who truly take advantage of the TPIA and are really, they try to abuse government officials by their use of the TPIA. And we wanted to be a part of the solution to that problem. And we worked tirelessly with all the folks in the task force to come to a compromise that was not going to close off access to information that was needed, but was going to address this abuse of the system. And that bill was carried by Representative Ashby and Senator Nichols. There were also some measures that, as Frank said, if we couldn't agree to it, then we just moved on. But these were measures that were introduced, but they were not agreed upon. One addressed the dead suspects problem that Brian mentioned. Another addressed the issue of governmental entities who, after they have been sued for withholding information, hand over the information, and then the requester has to foot the bill for the attorney's fees because the court sees the issue of attorney's fees as moot at that point. The third was dealing with record layouts, being able to have access to information from governmental entities in a searchable or sortable format so that you don't just get a data dump without the key to what do each of these columns mean. We had two others, one dealing with use of force and the other dealing with trying to fix the State Fair of Texas versus Riggs decision, in which a governmental entity or a non-governmental entity was able to sue a requester for making a TPIA request to them under the Declaratory Judgment Act and get their fees back. So the start of session, things look good. We've got at least 10 bills agreed upon. We've got a few not agreed upon, but we have a nice platform going forward. And Representative Capriglione and Senator Watson, right before session starts, hold a press conference explaining the importance of this legislation and the bills they're going to be carrying.
Now, the first bill is related to a recently created loophole. We call it the Boeing fix, if you will. And that started because the company Boeing had tried to increase the number of exceptions effectively that are inside of the Public Information Act. The intent of the Public Information Act is to provide and to provide this documentation, to provide this data to the public, to provide it to the taxpayers. But there are exceptions, but they're very specific exceptions. And so what Boeing had said was that they wanted to add an exception for not just proprietary information or trade secrets, but also for competitive reasons. Not competitive in terms of the government entity, but competitive for Boeing itself. The AG's office, Ken Paxton, fought that in the lower courts, won in the lower courts, but the state Supreme Court said that, yes, if you can stop disclosure just simply because you think that it will hurt your business. One of the things that is a result of this bill, and I think is just a huge loophole inside of the bill, and what that means is that effectively any business, anytime, will be able to stop an open records request anytime they believe that it will be a competitive disadvantage. We've seen musicians doing this, transportation companies doing this, we've seen universities doing this, and if we don't get this bill fixed, and we don't get this fixed in this session, then over the next 2 years, the Public Information Act will effectively be moot. The second bill that we filed is related to a case, Ken Paxton versus Greater Houston Partnership. What we have there is a quasi-governmental nonprofit agency that takes public money, uses those public money to do effectively public services, and always historically, it's always been the case that a citizen could go and file an open records request to get information about how that public money is being used or even how other money is being used. But again, the Supreme Court changed that nuance, and what they said is that we're going to change that from supported to sustained. And what that's meant is it's created another loophole in our ability as taxpayers to find out that information. Just a quick example is in Fort Bend County. Okay, they've created their own partnership, this economic partnership. Money comes in from the county. You also have money that comes from members. That organization then goes out and performs government services. The public is not allowed to go and view how that money is being spent. Not surprisingly, what you find out is a lot of those contracts that partnership goes and doles out are members of that partnership. That's just not right, and it's important for us to be able to fix those loopholes, and that's why I'm just so honored to work with the folks up here on those items. I think these are two very important issues, and I think they're important for the taxpayers. It's taxpayers' money. They should have the right to know how it's being spent.
So, gentlemen, what happened during the session? Representative Capriglione?
So bathrooms. There were just, it was a very, I'll say there's a bunch of different things that happened, but it was, I would say, one of the more difficult sessions. I've only been in 3, but I would put this one on the bottom in terms of trying to get any message on anything across, right? So we're trying to, in my mind, work on real issues, real things, and of course, anyway, not everybody was on board with that thinking, right? So that's one. I also think we did start out right. You had the stakeholder meetings before. We held them during session. We told everybody ahead of time what we wanted to do. We were open about how we were going to do it. And, it didn't work out for a variety of reasons. I know going forward, I've learned a lot, okay? And maybe we're going to have to change exactly how we want to get this done. I know since session has ended, some of those same folks that were kind of on the opposite side of the table have kind of come back and said, all right, listen, we just didn't have the time then to go through all of it, but we're willing to work with you now, and I'm going to take them at their word that we will be able to do that.
Brian, you have something to add?
Yeah, as an investigative reporter, I have a history of being less diplomatic than the representative. State Representative Gary Elkins screwed us. He is the head of the Government Transparency Committee, where all this went through. He intentionally bottled it up. He intentionally was involved in the process leading up to and into the session, and he looked us right in the face and stabbed us in the back. He's the problem.
Well, let me also try to be.
You are not as politically.
I'm sorry, I don't want to mince words.
Let me add a little diplomacy here, perhaps, and that is that in the stakeholder groups, we genuinely thought we had the interested parties in the room. We had the AG's office. We had the governmental entities. We had the requester groups. What we didn't have in that room was this, and this ended up being our wall of opposition. We didn't have the third group that Frank mentioned in his opening. We didn't have the private entities who are doing business with the government. And that ended up being an enormous wall of opposition for us. Frank, you've got something to talk about?
Well, I'm certainly going to agree with you on that. You know, I didn't work on this during the session. I was doing bill referrals and working on another committee, Ways and Means. But it was obvious to me that there was a lot of opposition, and it's really hard to put all of those. And this is actually not all of them. This is maybe half or a third. I don't know, but it's really hard to put that. If you want to negotiate with this group, it's pretty hard to do it because they're all different. They're medical hospitals, medical associations, chambers of commerce, engineers. They're all different, and they don't all belong to one group. There's not like some person that we could bring to a stakeholder group to represent their interests, and I think it's going to be a lot of work. It's just going to be a matter of going to all of them and trying to find, okay, is there anything we can do? What can we do to help you with your concerns? And a lot of work.
Well, and there were many that just wanted a straight carve out. I mean, Representative Capriglione can speak to that. I mean, we tried to address each individual group's issues, and it was very difficult.
You're right, and it was, in a way, it was like whack-a-mole, right? Because we would solve one group's or one industry's problem, and that would either not be enough for a group or it would actually create a problem for others. And so we would just hear about groups to say, okay, listen, we're different. We're different because we do this. And the problem was you say yes to one, you have to come up with more and more reasons why you don't say yes to everybody else. And it was hard to get them all in the room just because there's so many. I mean, just one of those is AECT. Well, they represent dozens of electrical companies and so on. And you can just go through the list. And even inside of one association that was being represented, some may have been okay with it and some may not. But that being said, I think what we do need is that other group, which is the public, right, to go and say, and so what I've thought about is going to the parties, right? So we have a Republican Party convention, there'll be a Democrat Party convention, make this part of the party platforms and say, listen, if you want to consider yourself a Republican, if you want to consider yourself a Democrat, at the very minimum, you have to say that you represent the people. And so what I think one way is to try and get the grassroots side. We would hear from lots of folks who just get, there's scorecards when we vote, right? There's little pieces of paper. You don't have to do much thinking necessarily, and it just says vote yes, vote no. And on these types of bills, unfortunately, it was hard to combat that.
So what did pass? Basically what passed were the agreed upon measures that were promoted either by the governmental entities or the AG's office. The IT security bill passed, the URL fix passed, and the vexatious requester bill passed. We actually did get our attorney's fees bill passed, and then it was vetoed by the governor. So just so you know what the vexatious requester bill does is it updates 552.275. This was the reform that Senator Wentworth did years and years ago, and it allows yearly requirement was too cumbersome for record-keeping purposes, and so we came up with this option of a monthly time period. If someone is declared a vexatious requester and they haven't paid for their prior request, then the governmental entity does not need to do any work on a new request until a payment is made or the request is withdrawn. It also provides for requests to be considered withdrawn if the requester fails to inspect or duplicate the items after 60 days. Believe it or not, we heard in the task force meetings that there were closets dedicated to old requests that had been compiled that were very cumbersome. I see Hadassah Schloss nodding her head because the governmental entity didn't want to have to do the work again, but there was no mechanism for that to be considered withdrawn, so that was added. So all of these were good measures that we believe address the vexatious requester problem in a very thoughtful manner and that came out of that task force. The IT security bill, this was something that the AG's office very much wanted, and it adds language to an existing TPIA exception for the release of information dealing with computer systems and securities that are collected, assembled, or maintained by the governmental body to prevent, detect, or investigate a computer security incident. This was, again, intended to address those daily logs that are done by the governmental entity to determine if there's been any breach in security. It's not intended to prevent the public from knowing if there has been a computer security breach. Okay, so what didn't pass? Well, this is a long list. So what didn't pass was pretty much everything else. You can see in red all the things that were held up in the GTO committee and that weren't allowed to have a vote, and that's basically to the point that Brian made. The GTO committee, we were unable to get a number of our measures even up for a vote in that committee. But essentially all of the other measures did not make it. The dead suspects measure was one of the few measures that did make it out of GTO, but it got to calendars too late. And the Boeing Light, as we call it, measure that was carried by Representative Canales, just dealing with the issue of performers in parades and having access to those contracts, did make it out of GTO, but it died in the Senate when it was kicked off of the local and consent calendar very late in the session. So after spending a whole lot of time and energy and lots of blood, sweat, and tears trying to work with the other side and creating this task force and trying to build consensus, and then having the experience that we had this session, it leaves me to wonder, does building consensus matter? And maybe that's a rhetorical question, but I would like our panelists' thoughts on that. Frank, you want to start?
Sure. I think it always matters. I mean, there are many interests that come together in the legislature, have come together to fight in the legislature, and I think, I'm old-fashioned, but I think that you should always be looking for common ground, and it's a lot of work, and especially, in something like this, it involves so many people. Yeah, I mean, as Donis will point out, I'm optimistic.
Good to hear. How about you, David? You participated in all those task force meetings. What do you think?
Well, thank you for inviting me to those. Those were very helpful. I think that's the right thing to do. I think, as my colleague said, that wall of opposition, it's very difficult to determine when you're trying to put together a group like that, who's going to be against everything. Sure, maybe you knew Boeing would be against the bill on Boeing, but you didn't realize that all these other interests would come out, medical societies and others that simply didn't want their members' information being out there for whatever reason. So I think you still have to try to build consensus. Sometimes it's going to be a whack-a-mole, and you're going to have these other people come in. And I think that's a better process sometimes than one or two people going to a member of the legislature. And this happened a lot when I was in Florida and saw it a lot. And there was an idea, and that person just took the idea and filed it as a bill without any task force or working group working through it. So I think you guys are on the right path. I'm privileged to be a part of it because there's some great minds in that group. And what I just, got to roll up the sleeves, hunker down, and go for it again. Work a little bit harder and a little bit deeper next time, and I'm there to help.
Thank you. Representative Capriglione, do you have anything to add?
The only thing I'll add is we have hopefully a long memory, right? And so a lot of these groups have said at the very end that that they would be supportive of certain changes. So I just want to make sure that when we start, we remember and say, hey, you told us the day afterwards you would do this. So let's just start off with where we ended, and let's start putting people's names on it.
So by the end of session, what started out as a very optimistic session ended with more like Brian's comments. I think Representative Canales.
I'm not a big consensus fan.
Well, I think Representative Canales, in this personal privilege speech, channeled his inner Brian Collister. So I'll let y'all hear it.
Chair recognizes Representative Canales on a matter of personal privilege.
Mr. Speaker, members, I've never given a personal privilege speech on this floor, and I don't take the fact that I rise to do so lightly. But I rise today to cast light on what I call a public villain, someone who dwells in the shadows of corporate greed and would blind the public from its fundamental right to know. During the interim, McAllen, Texas, held a holiday parade and a concert. And from that concert ensued a controversy which would ripple across our state and make national news. The issue was transparency. The public's right to know how their government spends their tax dollars. The public's tax dollars. The city of McAllen had spent and lost hundreds of thousands of taxpayer dollars on a concert. A concert. Local news outlets such as the McAllen Monitor requested documents and contracts to try to confirm what we knew. They appealed that request to the Attorney General and citing a language from a Boeing case from the Texas Supreme Court stating that the information was competitive, would put them at a competitive disadvantage. The public was outraged. I was outraged, and rightfully so. How could a city or any local state government hide how much they had paid for a concert? For government exists by and for the people. Chapter 552 of our code, our government code, states that government is the servant of the people and not the other way around. To this day, almost a year and a half later, we don't have any idea how much that municipality spent, how many hundreds of thousands of dollars were lost to artist Enrique Iglesias, or whatever his name is. In response to this egregious violation of the public's right to know and how government spends its tax dollars, I filed HB 349. My bill merely said that when the public expends funds on parades, concerts, it has to be privy to open records. The bill was voted unanimously out of the Transparency Committee, unanimously out of the Senate Transparency Committee. We're across the desk of a senator who we later learned had bigger plans for my bill, who dwells in the darkest parts of corporate conspiracy. They didn't want my bill because it was an attack on the precious Boeing ruling. It was a nick. It was a chink in the armor on how government spends your tax dollars, my tax dollars. That senator removed the transparency bill from the uncontested calendar, essentially bending to corporate greed. The senator will tell you he probably had other reasons, but make no mistake, he will be unmasked. This session, I've had the privilege of working with champions for public transparency like Representative Capriglione, Senator Kirk Watson. Texas has a long history of being a leader in public transparency, but I'm afraid that is no longer the case. What will we do to prevent another Sharpstown? Chapter 552 again states the people in delegating authority do not give their public servants the right to decide what is not and what is good for them to know. Yet in this chamber and across the hall in the Senate, members conspire to keep contracts between government corporations secret and the people in the dark. Some say ignorance is bliss. I say information is power. I stand here before you, standing not only for Texans, but all Americans, and I implore you, members, if you don't have the spine to stand for transparency, you don't stand for the fundamental principles that make us Texas and make us one of the greatest nations in the world.
Brian, you did a great job training him. So just so you know, even after this personal privilege statement, if I can get this to move to the next slide, I will. It got so bad that in the throes of the last days, when the voter ID bill was being debated, and there was a conference committee assigned to the voter ID bill, Representative Rodriguez of Bexar County had an amendment to that bill that would have said that the Secretary of State must prepare a report on the expenditure for its voter education program. Seems pretty benign. It was stripped in the conference committee. Why? Because there was concerns that it would expose proprietary information for contracts with outside vendors and the state. So the next question becomes, what do we do in the future? The good news is that a joint resolution was passed, and that joint resolution provides for the House and the Senate to work together on an interim charge to study the Texas Public Information Act and propose reform to that act. And Representative Capriglione, I'd love your thoughts on how you see that interim charge playing out and how the members of the public in this room can assist in that process.
Sure. I had talked to Chairman Hunter, who of course couldn't be here. He represents portions of Corpus Christi, and so he's busy now on that. But what we had talked about in our conversations and with Senator Watson is that we're going to use this to kick off all of this all over again, right? And sometimes the way to do this is with a splash. And so having this joint committee, I think, is the best way to do that. We'll talk about these issues, and I think in a very public light, bring some of these folks in that were opposed to this, invite them to this testimony, and in public rather than in a room in the Ag Museum or wherever, just say, hey, you're invited, please come, and tell us what you think we should be doing. Because what I want is some record, right, of where they stand, and I think that will kick off, hopefully, the press and the public and Facebook and social media and all that kind of stuff. People scratching their head, just like Representative Canales said, for members of McAllen who are absolutely on board with this, right? So, I'm looking forward to that. We're going to have a variety of different interim charges as part of that, and I look forward to helping him on that.
Super. Frank, do you have any suggestions for us?
I would keep talking about it. You know, keep the issue alive. Talk to as many people as you can. It's not just talking to the people on the wall of opposition, but just anybody, political parties. I think those are all constructive things. I think the one thing that will doom this is if people stop talking about it, because they'll think, oh, that's not a problem anymore. So that would be my advice.
David, what are your thoughts?
Yeah, don't have much more to add. Just, you know, the opposition group, the group that you all put together, getting them in a room. I think the great idea of having this joint committee talk about the issue now and start early on this interim project will be a healthy debate. And, you know, again, coming from a business perspective, my company hasn't taken that stance, but I get it. You see in Business Week, you see in Forbes, you see in Cato, Texas is the #1 environment for business in the state, in the country. And there's all of these rankings where Texas is #1, Texas is #2 for jobs, Texas is #1 for bringing new people into the state. And that wall of opposition is using that material to provide concerns that giving out this information may be deleterious to business, may start problems with government contracts if all this comes to light, which I don't feel is true from a personal perspective, but I know that they are using some of those arguments. So I think just being prepared and having the ammunition to fight some of that will be helpful.
And Brian, how do we get that ammunition?
We fight. We give them hell. We get out there and we do it on a legislative front, we do it on a journalistic front, we do it in social media. And we all have one mission, which is to make people who are not in this room understand why it's important. People who are not in the legislature, not journalists, not attorneys. Why is it important? And I'll leave you with this one snapshot. The state of Texas, as we mentioned, the courts have ruled that your date of birth is not public information. It is considered sensitive information because if released, you could be the victim of identity theft. Our state statute, our Business and Commerce Code, also lists your date of birth as sensitive information that, if released, could reveal you potentially to identity theft. Some people agree, some people disagree, but that's on the record. In the meantime, the state of Texas sells your date of birth. They sell it in the driver's license information, and they sell it in the voter rolls and make millions. So on one hand, you have the state telling the rest of us you can't have it, and then they sell it like candy to whoever wants to pay up.
Absolutely.
Okay. So one more actionable item, and when these bills came to our committee, there's a group, which I happen to be a member of, but it's a conservative group, and they go and they provide some sort of advice for those members on that committee in terms of whether they like it or they don't. And on these bills, they said they don't. And they really quickly clothed it in this idea of this is more regulations, right? Without having to dig deep, they know some of the members aren't going to read the bills or whatever. They're just like, vote no, this is a bill that provides more regulations, hurts businesses. And so for most Republicans, that's like, oh, well, then no. And so while we were working on this, I also discovered that some conservative groups were opposed to it as well. And they did that, not, in my opinion, for conservative principles, but rather for conservative money, right? So what I talked a little bit about about getting your party involved, and this is why I think it's important. And hopefully we're able to get this committee to meet right before the conventions meet. So whether you're a Democrat or you're a Republican, on March 6th at 7 o'clock, you can show up where you voted, wherever the election day voting is, and they have a delegate convention. Has anybody here ever been to a delegate convention? Okay, a handful. So there's this event right at 7 o'clock where you vote, you meet Republicans on one side, Democrats on another, and you can go and you can propose planks for the platform. You can go and you can say, this is important to me, a one-sentence deal. You vote it out of your precinct convention. It then goes to your senatorial convention, and then hopefully it makes it to your state convention. There's nothing I want more than to see both parties have at least one plank in common, and for this to be that plank. So as part of, I think, this committee, when that comes out and we're having that meeting, I would like to, and I will propose a plank that everybody can copy, paste. If nothing else, show up on that day at 7 o'clock, propose it, and let's get something through on both sides. So that way, in the Republican Party now, what we've added is something called censure, right? If you don't follow the party planks, you will be censured. Well, I would like for any member of the legislature to have the answer to their party if they're not willing to support transparency.
It's a great idea, and that's something that we're encouraging people, as a party plank. Similarly, we're encouraging people with their editorial boards and others to ask the simple question of candidates: do you believe that taxpayers have the right to know how their money is spent? It's a simple question. They should be able to answer it. We're also encouraging people who are doing Public Information Act requests that are being denied, that involve and their request involves the use of taxpayer dollars, to notify FOIFT. We're building a database of examples throughout the interim. And keep track of instances where the inability to obtain dates of birth have also affected your ability to confirm one's identity. Notify FOIFT of that as well. And finally, because this interim committee will hold hearings, and those hearings will be made open to the public, be a part of that process. Come testify at the hearings. Let the lawmakers who serve on the interim committee hear from you about the importance of transparency.